Good morning, everyone. This public hearing is being held as part of the national inquiry being conducted by the Commission on the impact of climate change on the human rights of the Filipino people. This proceeding stems from a petition filed before the Commission docketed as CHR case number CHR-NI-2016-0001. The solemnity of the public hearing shall be upheld at all times. Respect should be accorded to everyone present. The clapping of hands and unnecessary remarks shall not be allowed and may be regarded as direct contempt of the inquiry panel. Cell phones should be turned off or put on silent mode while proceedings are going on. All rise. The inquiry panel for today's proceedings are Honorable Commissioner Leacita Nodra Armamento, Inquiry Panel Chairman of the NICC Honorable Commissioner Roberto Eugenio T. Cadiz, and Father Pedro Walpole S.J. Please remain standing for the national anthem and the ecumenical prayer.
Bayang magiliw, pelas ng silanganan, alab ng puso, sa dibdib mo'y buhay. Lupang hinirang, duyan ka lang magiting, sa manlulupig, di ka pasisiin, sa dagat at bundok, sa simoy at sa langit mong bughaw. May dilagang tula at awit sa paglayang minamahal. Ang kislap ng watawat mo'y tagumpay na nagniningning. Ang bituing nag-araw niya, kailan pa may di magdidilim. Lupa ng araw ng walhati pagsinta, buhay ay langit sa piling mo. Aming ligaya na pag may mga api, ang mamatay ng dahil sa'yo.
Dakilang may likha sa kalingat pang-unawa, mangyari ang iyong diwa sa langit at sa lupa. Bigyan mo ng sapat ang lahat sa araw-araw. Turo ang magparaya, gaya ng iyong gawa. Iadya niyo kami sa pagmamataas upang maiwaksi ang lupit at dahan. At sa lumikha ng pamayanan payapa sa kalikasan, kabugayan, kakanyahan, paniniwala. Siya nawa, siya nawa, siya nawa, siya nawa.
Everyone may now be seated.
Good morning, Your Honors. Zelda Soriano, same appearance for the petitioners.
Good morning, Your Honors. Griselda Mayoanda, respectfully appearing for the petitioners.
Good morning, Your Honors. Respectfully appearing, Hasmina D. Paudak for the petitioners.
Thank you very much. The appearances of counsels are duly recognized. Before we go into the formal presentation of witnesses, may we know if there are parties here or their counsels who might want to manifest anything before the panel? Okay, we continue nonetheless to enjoin all interested parties, whether as petitioners or respondents, to participate in this inquiry. All our hearing dates have been published, and we welcome their contribution or participation to this inquiry. Counsels, are you ready to present your witnesses?
Good morning again, Your Honors. Our first witness for today is Dr. Vincent Hilomen.
All right, can we have the witness sworn by our lawyers? We invite you to sit on the witness stand. You may now proceed.
Thank you, Your Honors. Our witness, Dr. Vincent Hilomen, is currently the project manager of the Smart Seas Philippine project, which is funded by the United Nations Development Program Global Environmental Facility and implemented by the Biodiversity Management Bureau of the Department of Environment and Natural Resources. Dr. Hilomen has 29 years of experience as a marine reef scientist and biologist. We are offering him and calling him as a resource person to be able to explain the impacts of climate change on the fish and seaweed supplies, reef ecology, and food chain, and ultimately the country's food security. Before we proceed, Your Honors, may I be allowed to ask him preliminary questions?
Please proceed.
Okay, Dr. Hilomen, I have here 3 documents. The first document refers to an abstract entitled Effects of Climate Change on Food Chain Compromising Food Security. Do you confirm and affirm that this document consisting of 1 page has been submitted to the Commission on Human Rights?
Yes, I do. I emailed that.
And in this same document, there is a signature here. Could you identify the signature?
Yes, this is my signature.
Now, the second document, Dr. Hilomen, refers to a curriculum vitae. Do you affirm and confirm that this 1-page document has been emailed and submitted to the CHR?
Yes, I do.
And the signature which appears here, Dr. Hilomen, could you please identify this?
Yes, this is my signature.
The last document, Dr. Hilomen, refers to a printed PowerPoint presentation consisting of 13 pages. Do you confirm and affirm that you emailed this document, which was submitted later to the Commission on Human Rights?
Yes, I do.
These documents, Your Honor, please, have been pre-marked. The first document has been pre-marked as Exhibit VVV and the signature as VVV-A. The second document, which is the curriculum vitae, has been pre-marked as Exhibit WWW and the signature as WWW-A. And the last document, consisting of 13 pages, has been pre-marked as Exhibit XXX, series until XXX-12. Do you confirm this, Attorney Esquerra? And we would also further manifest, Your Honors, that today Dr. Vincent Hilomen signed again um, the document entitled Abstract and his curriculum vitae. Having my last question, Dr. Hilomen, do you confirm and affirm the contents of all these documents that you emailed and which we later submitted to the Commission?
Yes, I do.
Now, Your Honors, may we then request Dr. Hilomen to give his presentation.
Dr. Hilomen, you can now proceed.
Thank you. Good morning, honorable panel of the Commission on Human Rights. This morning, I am tasked to explain the effects of climate change on food chain, how it can compromise our food security. Next slide, please. On this slide, I'm showing a diagram of the typical food chain. There are 3 columns here. The first one shows the food chain for terrestrial environment. The second one are the components of those food chain for each level. And the third one is an example of a food chain in the marine environment. It is important to note that man is always on top of this food chain. A food chain is the transfer of energy from one component to another. Firstly, at the base, we have the producers. These are the organisms which has chlorophyll, or those bacteria that does not need sunlight. Those with chlorophyll needs sunlight to create food. So they use water and carbon dioxide to produce food. Then the energy that they store in their body is used by the next group. So in the next group, we have here what is known as the herbivores. Where they can be insects, which eats flowers. They can also be cows that eats grass, even hogs and chicken, which comprise our meal. So the 3 main items, beef, poultry, and fish, well, fish is on the other side. Well, beef and chicken and hogs are on the second level. When man eats vegetable, they are on the second level. But the nice thing about man is that it can also eat meat. So it occupies also the other food chains, the other levels. So this is on and on until the top, which we believe it's also man. On the right side of the figure, it starts with the unicellular and microscopic organisms we call as plankton. They also have chlorophyll, and they are also covered with a test. It's calcium carbonate test, some of them like the diatoms. So what they do is they capture light energy when they're floating in the sea and convert this into food. Since they're very, very small, they cannot be eaten directly by the bigger fish. So what you need is another level to link that plankton to the fishes. And this is another important group which is known as the zooplankton. So they occupy the second level, and it is the zooplankton that forms part of the diet of the smallest fish. Then the smallest fish is the diet of a big fish, and the big fish is the diet of the bigger fish, and up the chain until the sharks and the orca, as you can see here, and then man. So at each level, the effects, they can be hit by human, man-made disaster or natural disaster for this matter. And if that happens in a very, very wide area, it can compromise the food chain, and the food security of man is compromised. I will explain it in this way. So how then does climate change, a natural disaster, triggered a natural disaster triggered and exacerbated by man's behavior affect food chain and compromise food security. Next slide, please. I'd like to emphasize that the effects of climate change on the marine environment are encapsulated in four effects, namely increase in sea temperatures and from the effects of greenhouse gases. Second, sea level rise because uh, there is warming of the oceans. The ice caps at the polar north and south begins to melt, and they increase the sea level. Third is ocean acidification. The cause of warming is actually the increase in greenhouse gases emission, which are then absorbed by the oceans. And this carbon dioxide absorbed by the ocean are changed into ions like carbonic acid plus the carbonate ion. When you have plenty of carbonic acid, that's the time you increase acidity in water. And I'll explain how increase in acidity later influences the food chain. And fourth, the last is more intense weather disturbances from the accumulation of heat and interactions of oceans and land masses. A good example of this is Typhoon Haiyan. Usually, we do not have the category 5 kind of weather disturbance, but for that very first time, we were hit by category 5. Hindi lang sa Pilipinas, but also elsewhere. No? Next slide, please. All right. So the first effect on increase in temperature. When the water temperature increases, the zooxanthellae that is housed in the corals, which are the habitats of fish, are expelled because they're not used to increase in temperature. So you only need a 3 degrees Celsius rise in the ambient temperature, and when it is prolonged for about 3 to more than a week, then you begin to see effects like coral bleaching. When there is coral bleaching, the corals die. And once the corals die, they begin to disintegrate if they cannot recover straight away. And what happens is the habitats of reef fishes, which man eats, are compromised. So if fishes do not have habitats, they are less likely to survive. Examples of these fishes would be the damsel fishes, which are the feeds of the bigger fish like the snappers or the maya maya. And they are also feeding on, fed on by lapu-lapu or the groupers, which occupies the top of the food chain on a reef. So if we have that, then food is compromised. No? Next slide, please. The other effect of increase in temperature is by way of confusion among marine organisms. Marine organisms usually follow a biological calendar, and the cues of these marine organisms are the different seasons. So when the season changes, they say it's time for us to spawn so that we can replenish our populations. But because of climate change, they begin to be confused. When do they spawn and when do they not spawn? And the most aggravating thing here, most of the organisms spawn in synchrony with other organisms, so that when their young is born, the abundance of food for the young is also plentiful. So when they are confused and they begin to spawn, but there is no synchrony for the food of this young, then what you end up is a disaster also for that particular spawning period. All right. So reproductive cycle, etc. Then the abundance also. Next slide, please. Then the other scary thing about being in the tropics is when we have a strong, intense climate change and the water begins to warm up. Because fishes has the ability to be mobile, they can actually escape the tropics and move to higher latitudes to seek cooler waters. But the thing is, the coral reefs, which are sedentary, they cannot move. They stay there and they are affected by coral bleaching, etc., and they die off. But what is the impact of this? It means that the food security for tropical countries are being threatened because it will now take fishermen to move further up in the higher latitudes to obtain these fishes. Next slide, please. Here, sea level rise is a good example. Here is it intrudes higher into the land masses and can influence the water table of land. And then this has great impact on our agriculture because if you use groundwater to water your garden, water your farms, which has salinity, then you don't get the production that you want. Our farms are also threatened later by another effect, no? When we go to the fourth one. Next slide, please. By the way, in the other one, no, when the water table is influenced by seawater intrusion, drinking water is also affected. Next slide, please. Here, this is sea level rise again. The habitats that are really vulnerable in the marine environment are the seagrasses and the mangroves. If you look at a mangrove forest, they really have this zonation. The ones that are very near the sea, the species Avicennia marina are very, very dominant, plus Stylophora, no? And then as you go inland, the species changes, and those species that cannot tolerate higher salinity are located upland. When you have sea level rise, sea level will intrude into the land and affect those mangroves that do not have the capacity to tolerate salinity, and hence they can die off. And if they die off, then you lose an important breeding ground, spawning ground, and nursery ground of fishes, crustaceans, and many other food items for man. Next slide, please. This is a slide showing the effects of agriculture and sedimentation, which affects corals. When strong rains, when you have a strong downpour, the sediments become loose, and then it brings the sediments to the sea and then smother the corals. Next slide, please. Okay, this is an example of ocean acidification. So when the seawater becomes acidic, it's like the animals there are immersed in an acid solution. So what happens is all animals and even plants, this is in particular seaweeds, which possess calcium carbonate. The calcium carbonate is being weakened and corroded. It is similar to a person suffering from osteoporosis. But this time, the entire body is immersed in an acidic solution. So over time, when the oceans become acidic, you will begin to see less organisms with calcium carbonate. These are fishes with their skeleton, giant clams, or even the clams that we eat. Example ng giant clam, ng clams would be a simple tahong, the green mussels, no? the shell is made up of calcium carbonate. The coral reefs will also be affected because the entire skeleton of coral reefs are made of calcium carbonate as well. Um, Even crabs, shrimps, their outer skeleton are composed of calcium carbonate. Next slide, please. Okay, so those are the effects that I can explain about the effects of climate change on the food components, which will then affect food security of man. So the only way that we can prevent this from happening is we should significantly reduce the triggers of climate change. And the triggers of climate change, number one is the greenhouse gas emissions. And number two, we should promote technology that efficiently use and convert energy. This includes the renewable forms of energy. Number three, we need to change the behavior of man because even right now, when we have the Clean Air Act, you can see from the backyard there's still plenty of people burning dried leaves. So the carbon dioxide captured during photosynthesis in the tissues of the leaves are sent back to the atmosphere when they burn it. Second would be invest in actions that sequester excess carbon from the environment. So restore our forest, our peatlands, mangroves, seagrasses, coral reefs. The mangroves are 250 times better carbon dioxide sequesters than a tropical rainforest. Seagrasses are about 200 times better than a tropical forest. And that's why quite recently the DANR is looking at the marine environment because for a long, long time they have neglected the marine environment. But now they have plenty of attention to the marine environment. Next slide, please. I think that's my last slide. Thank you for your attention, sir.
Thank you, Dr. Hilomen. Your Honors, please may we be allowed to ask a few questions.
Please proceed.
Now, in your presentation, Dr. Hilomen, you identified four major effects of climate change on the coastal and marine ecosystems. Among the effects you've identified here, which among these has or have the most profound effect on food security?
For now, the first one, which is the increase in temperatures, and I think the fourth one. The first one, the effects of increase in temperature has really affected vast majority of coral reefs in the country. For example, the Bolinao Reef Complex was hit by the 1998 El Nino. And so 90% of the corals in the Bolinao complex perished. Once they perished, if the Bolinao Coral Reef Complex was healthy, where you have plenty of herbivores there, then they can clean the surfaces of the dead corals and allow new larvae of corals to settle and grow. But that did not happen because there's no more herbivores there. And so the coral reefs in Bolinao has been transformed from a coralline community, which is quite nice for fish that we eat, into an algal community, which of course, as for now, the algae that grows there are mostly sargassum, which are not directly eaten by man, but they can be used as good fertilizers. So there is a change in community and habitat, and that's a form by which they no longer can fish the good and top carnivores in Bolinao. The last one can be explained when Typhoon Haiyan hit the country, you can see the destruction and devastation. Even the farmlands in the region where Haiyan landed were damaged, and so food security there, like the rice fields, etc., were also uh, destroyed.
Just a quick follow-up, Dr. Hilomen. In relation to the increase in sea temperature that you mentioned, besides Bolinao, are there other areas in the country where you have seen these trends taking place?
Yes, the eastern side of southwestern side of Palawan, from Aborlan down to Batarasa, the reefs there, the fringing reefs there are all now covered. Well, maybe 80% are all covered with algae, and we know that they are effects of coral bleaching because the reef skeleton is intact, but it is dead and it's covered with coral, with algae. Um, Corals that has been affected by dynamite blasting is different. They're all flattened because of the blast. But this, you can still see the branching corals standing, but they're dead. In addition to Palawan, there are also other reports done by the Coral Bleaching Watch of the country. So I think it's all over the country, except for the most remote parts, which we did not receive any reports. But we think it was affected as well.
So do I take it to that coral bleaching is a common observation in all fishery areas in the
Yes,
country?
particularly for reef fishes.
That would be all, Your Honors, unless the commissioners would have questions for Dr. Hilomen.
Thank you very much, Commissioner Armamento. We'll field some questions to our witness.
Good morning, Dr. Hilomen. I would like to ask, you have recommended here that you have to reduce triggers of climate change. There must be some behavioral change in man. Do you have any specific recommendations on the changes that man should undertake to either abate or, if not, reverse climate change?
Yes, ma'am. But changing the behavior of man is a very, very tall order. Like, for example, for the Philippines, no, the use of plastics, the production of plastics uses energy, and energy you produce using gas, no, and you have emissions as well. And the Philippines right now is the third polluter globally, second behind China and Indonesia. In the ASEAN region, there are 5 countries that are in the top 10. Now, if you look at the human behavior, they usually just throw plastics everywhere. So and these plastics find their way into the marine environment. And well, the production of plastic triggers gas emission. The other thing is that the tendency of many people not to go into renewable forms of energy, well, because it's very costly for now, then they just probably, you know, burn incinerate their garbage in the backyard. But that's quite little, no? The biggest gas emission polluters really are not us, but the United States and China. Both countries combined for the 40% that are emitted for the entire planet. Um, Again, if we just think on how we can conserve and use energy, like turn off lights just to save, burning of fuel, probably we can help. But I'm not sure how much dent Filipinos we can do for the entire country, for the entire world.
We have no further questions for the witness.
We request then, Your Honors, that Dr. Hilomen be excused.
Thank you very much, Doctor.
Thank you, sirs, ma'am.
Thank you very much.
Are you ready to? I understand that you changed the sequence of presentation of witnesses. So is our second resource person here already?
Your Honor, may we request for a 5-minute recess? We'll just check the arrival of our
All right. If not
next
yet, then
witness.
maybe we can go to another witness first. But yeah, we can have a 5-minute break. So session is adjourned for 5 minutes. All right. We may now resume our session. The session is now in order. Councils, are you ready to present your next witness?
Thank you, and yes, we are ready, Your Honors. May we call on our second witness for today, Mr. Marcos Aureliana.
Please swear in the witness. Thank you, councils. You may now proceed.
Your Honors, Mr. Marcos Aureliana is the Director of the Environment and Human Rights Division of Human Rights Watch. We are offering his presentation today to share his views on the legal framework of human rights responsibility of corporations, including a summary and analysis of the opinion of the Inter-American Court of Human Rights, recognizing an autonomous right to a healthy environment and nations' extraterritorial responsibility for environmental damages under the American Convention on Human Rights. It should be an example, and that is the purpose. So, may we now proceed for preliminary questions, Your Honors?
Please proceed.
So we received several documents from Mr. Marcos Aureliana, and these documents received via email are the following. One, profile of Dr. Marcos Aureliana consisting of 1 page, and on the same document, bearing a signature of the same name, pre-marked on 21st of May as Exhibit BBBB for the profile and Exhibit BBBB-A for the signature. This morning, we asked the pre-marking of 2 additional documents entitled Statement of Mr. Marcos Aureliana consisting of 7 pages and a PowerPoint presentation of Marcos Aureliana consisting of 11 pages. They were pre-marked as CCCC to CCCC-6 for the statement and Exhibit DDDD to DDDD-10 for the PowerPoint presentation. For Attorney Esguerra's confirmation, Your Honor.
Attorney Esguerra, the copies that we have do not bear the signature of Mr. Aureliana. Okay, the original.
Yes, Your Honor, which is now in the marked exhibits folder.
All right, and then in the exhibit CCCC, there is no authorship. No signature appears on the last page. Has it been properly signed?
It is properly signed, Your
May
Honor.
I see? Sorry, I just want to. All right. Thank you. Thank you, Counsel. You may now proceed to examine your witness.
Mr. Marcos Aureliana, good morning. May you confirm and affirm to this hearing that you indeed authored the said documents and that you signed those documents, and also on the authenticity, correctness of all the condos documents?
Thank you. Yes, I am in a position to affirm so.
Thank you very much. Our resource person is now ready to present his summary based on the statement that he submitted.
You can now proceed, Mr. Orellana.
Thank you very much, Your Honors. Good morning. I am honored to appear today before the Philippines Commission on Human Rights. My name is Marcos Orellana. I am the Director of the Environment and Human Rights Division at Human Rights Watch. Human Rights Watch is an independent international organization that defends the rights of people worldwide. We investigate human rights abuses, expose the facts widely, and pressure those in power to respect rights and secure justice. Human Rights Watch has done research and advocacy on human rights issues in the Philippines for more than 25 years. My area of expertise is public international law, having lectured and published in the field for more than 20 years. The case before you has great significance for millions of people who are and will be impacted by climate change. It also has great significance for humanity's sense of justice and responsibility towards the totality of life on the planet. In the time available to me, I will speak about two questions that directly concern the responsibilities of carbon majors, the largest companies producing crude oil, natural gas, coal, and cement, who are also the world's biggest greenhouse gas emitters, for human rights impacts resulting from climate change. The first question: what are the responsibilities of business enterprises under the United Nations Guiding Principles on Business and Human Rights? The second: what are the key elements of the recent advisory opinion on human rights and the environment rendered by the Inter-American Court of Human Rights? The first question, next slide please. The first question concerns the corporate responsibility to respect human rights. Back in 2011, the UN Human Rights Council adopted, by consensus, the UN Guiding Principles on Business and Human Rights. These guiding principles reflect high-level agreement after decades of debate at the international level over the human rights responsibilities of business enterprises. One of the key achievements of the guiding principles was precisely their ability to gather political consensus at the United Nations. The UN Guiding Principles guide the implementation of the Protect, Respect, and Remedy framework that the Special Representative of the Secretary General on Human Rights in Transnational Corporations and Other Business Enterprises, John Ruggie, presented to the Human Rights Council in 2008. Under this framework, governments have obligations to protect against corporate-related human rights abuses. Business enterprises have responsibilities to respect all human rights, and victims are entitled to an effective remedy. Concise as it is, this framework reflects international legal developments in the field of business and human rights. Next slide, please. The UN Guiding Principles firmly establish corporate responsibility to respect human rights. Corporations are expected to take proactive steps to ensure that they do not cause or contribute to human rights abuses within their global operations and respond to human rights abuses when they occur. Next slide. For example, Human Rights Watch has investigated several instances where companies have been responsible for human rights abuses. We have documented how illegal logging in Indonesia jeopardized the sustainability of forest use and global efforts to combat climate change. We have also reported how the Porgera mine of Canada's Barrick Gold Mining Company in Papua New Guinea dumped 14,000 tons of liquid mining waste daily into a nearby river. Earlier this year, we exposed human rights abuses and forced labor in Thailand's fishing industry. These and many other cases of abuse highlight the importance of the corporate responsibility to respect rights. The key tool in the UN Guiding Principles to operationalize the responsibilities of businesses with respect to human rights is due diligence. Human rights due diligence is a process to identify, prevent, mitigate, and account for companies' impacts on human rights. Companies are thus expected to establish and implement effective screening, monitoring, and response mechanisms that permit continual analysis of human rights risks. Specific steps that corporations should take to fulfill their human rights due diligence responsibility is to conduct a risk assessment, prevent or mitigate that risk, and ensure access to a remedy when they have caused or contributed to the harm. Corporate human rights due diligence should address all internationally recognized rights. This is because companies can and do interfere with the realization of a wide spectrum of human rights. That said, some rights will be more relevant than others depending on the particular industries or circumstances. In the case at hand, the issue of the responsibilities of carbon majors for human rights impacts resulting from climate change particularly involves the right to a healthy environment, the right to life, the right to health, the right to property, and the right to food. The impact of a company's activities on human rights may relate to its direct operations, its supply chains, and its products and services. In the case at hand, carbon majors have conducted activities that result in the concentration of greenhouse gases in the atmosphere, which in turn causes global climate change. The corporate responsibility to conduct adequate human rights due diligence extends beyond corporations' direct operations to include their global supply chains. Individual companies' global supply chains often involve large numbers of suppliers or subcontractors, including some who are part of the informal sector. Due diligence does not involve limitations based on nationality or location of suppliers. Next. For more than 2 decades, Human Rights Watch has documented human rights abuses in the context of global supply chains. We have documented hazardous child labor in tobacco farming in the United States and Indonesia. Earlier this year, we exposed human rights and environmental abuses in the supply chains of jewelry companies, including forceful displacement of indigenous peoples from their lands and pollution of waterways and soils with toxic chemicals. Under the UN Guiding Principles, companies should ensure that their business activities, including through their supply chains, do not cause, benefit from, support, or engender human rights abuses. Despite the importance of the UN Guiding Principles in articulating corporate responsibilities, they are not a panacea. Critically, they lack any mechanism to ensure compliance or to measure implementation. This flaw of the guiding principles underlines the importance of the efforts currently underway at the Human Rights Council toward a binding international treaty on business enterprises and human rights that can help secure human rights accountability. What's clear is that the UN Guiding Principles set an important benchmark for the expectations of society on the conduct of corporations with respect to human rights. Many of the standards in the Guiding Principles, although not binding, are based on international human rights instruments. It is therefore incumbent upon national human rights monitoring mechanisms, such as the Philippines Commission on Human Rights, to ensure that the corporate responsibility to respect human rights is upheld. The role and importance of human rights monitoring mechanisms, especially in cases involving emerging issues of international law, such as those raised by environmental threats, takes me to the second question. The second question for me today concerns the advisory opinion on human rights and the environment published by the Inter-American Court of Human Rights in February. This opinion is highly significant for the case here because it addresses both the extraterritorial dimensions of international human rights law and the human right to a healthy environment. It bears recalling that the Inter-American Court, in addition to hearing cases of violations of the rights and freedoms guaranteed in the American Convention on Human Rights, can also provide opinions in response to questions presented by any member state of the Organization of American States. Advisory opinions by the Inter-American Court are legally relevant to all members of the Organization of American States. This includes the United States, where several of the carbon majors are domiciled. A good place to start the analysis of the Inter-American Court's opinion is with the basic facts. While technically the advisory opinion is not a case and therefore does not have a factual platform, the reality is that Colombia requested this opinion from the court in 2016, expressing concerns about the threat posed by large-scale infrastructure projects in the Caribbean to the human rights of the islanders of the archipelago of San Andres, located opposite Nicaragua in the Caribbean Sea. In 2013, Nicaragua announced plans for a grand canal connecting the Pacific Ocean and the Caribbean Sea, though construction has not yet started. Serious questions have been raised about the potential environmental impact of the project. The relevance of this advisory opinion extends beyond this specific factual background, however. In fact, the court explicitly noted that the questions addressed in its advisory opinion are of importance to all the world's countries. That is because the questions before the court concerned cutting-edge issues of international human rights law. One key question the court grappled with was this: since environmental harm often crosses state boundaries, does the American Convention protect persons affected by environmental harm coming from another country? The answer is yes. The court explicitly said that states' obligations under the convention extend to harms caused to people outside of their borders. To reach this answer, the court analyzed in detail the scope of application of the American Convention on Human Rights. The convention in Article 1, entitled Obligation to Respect Rights, establishes the duty of states, and I quote, to respect the rights and freedoms recognized herein and to ensure to all persons subject to their jurisdiction the free and full exercise of those rights and freedoms. The key element that determines the scope of this obligation is the term jurisdiction. Jurisdiction is a multifaceted term in international law. It can refer to the legal competence of an international tribunal to hear and decide a case. It can also refer to the basis upon which a state may exercise power, control, or authority, such as the jurisdiction of a state to prescribe and enforce laws in its territory or in respect of its nationals. In the context of the American Convention, a human rights convention, jurisdiction is the key that defines and limits the obligation of the state, which is responsible to respect and guarantee the rights and freedoms of persons under its jurisdiction. The Inter-American Court reasoned that the term jurisdiction in the American Convention is not identical to territory. In its analysis, the court examined the case law of the UN Human Rights Committee, the European Court of Human Rights, and other international legal sources that have recognized instances in which extraterritorial conduct by the state involves the exercise of its jurisdiction. The court concluded that the term jurisdiction can encompass situations of extraterritorial conduct of the state. The court further established that, in respect of extraterritorial situations, a person is under the jurisdiction of a state where it exercises authority over the person or when the person is under its effective control, be it within or beyond its territory. Now, this is a highly technical and complex matter, and the complications arise because of the multifaceted character of the terms in question. The Inter-American Court, having laid this principle of extraterritorial jurisdiction, next scrutinized: when does a person fall under the jurisdiction of the state in situations of transboundary environmental harm? The court noted that environmental pollution of one country can quickly become the environmental and human rights problem of another. In approaching the question of jurisdiction and transboundary environmental harm, the Inter-American Court relied on several grounds. First, it recalled the consistent case law of the International Court of Justice articulating the duty of states to avoid causing transboundary environmental harm. Second, it reaffirmed the duty of states to not pose obstacles to other states to fulfill their human rights obligations. In this regard, the court noted that activities within the jurisdiction of a state should not deprive another state of its capacity to ensure the enjoyment of human rights to persons in its jurisdiction. This analysis led the court to a crucial point. The state where the harm originates, and I quote, is in a position to prevent transboundary harm that affects the enjoyment of human rights of individuals outside its territory. End of quote. Perhaps I'll take a moment and repeat that quote, because this is the crucial point of the court's advisory opinion on this matter. The state where the harm originates is in a position to prevent transboundary harm that affects the enjoyment of human rights of individuals outside its territory. The conclusion of law that follows is plain. In a case of transboundary environmental harm that impacts on human rights, the persons whose rights have been violated are under the jurisdiction of the state of origin of the harm. The previous. In other words, the principle laid out by the Inter-American Court is that a state may be responsible for extraterritorial human rights violations where there is a causal connection between an activity in its territory or jurisdiction and the transboundary environmental harm that impairs human rights. Before analyzing the legal implications of this principle for corporate activities, I think it is worth highlighting that the Inter-American Court received a good number of amicus curiae briefs that helped it approach the questions put to it. The analysis on jurisdiction and extraterritorial human rights obligations laid out by the Inter-American Court has direct implications for corporate responsibilities in respect of human rights. In addition to reiterating earlier pronouncements that businesses should respect human rights and be accountable for the negative human rights impacts of their activities, the court's opinion explored the extraterritorial dimensions of corporate responsibilities. The court examined decisions by the Committee on Economic, Social, and Cultural Rights and by the Committee on the Elimination of Racial Discrimination, and noted that in respect of businesses registered in one state but that carry out activities outside of that state's territory, there is a trend toward the regulation of said activities by the state of registration. This trend, the court opined, is positive because it would allow states to guarantee human rights of persons outside its territory. In the end, the advisory opinion of the Inter-American Court of Human Rights makes an important contribution to clarifying human rights responsibilities for extraterritorial impacts. It explicitly underlined the notion that environmental degradation and the adverse impacts of climate change affect the effective enjoyment of human rights. Therefore, it comes as no surprise that the court also extolled the importance of the right to a healthy environment. The Inter-American Court of Human Rights proclaimed that, and I quote, "a clean environment is a fundamental right for the existence of humanity." End of quote. The court affirmed that the American Convention on Human Rights protects this right, and for the first time it explicitly outlined some of its components. For example, the Inter-American Court explained that the right to a healthy environment has both collective and individual dimensions. That is, it expresses a universal interest that is due to present and future generations, as much as its infringement also affects individuals. In that regard, the court noted that the right to a healthy environment is connected to other rights, such as the right to health, personal integrity, and the right to life, among others. Notwithstanding these interconnections, the court clarified that the right to a healthy environment is autonomous. In the court's reasoning, the autonomous character of the right to a healthy environment means that its content is distinct from the environmental dimensions of other rights. In that sense, the court highlighted that the right to a healthy environment protects the elements of the environment, such as forests, rivers, and seas. The analysis of the Inter-American Court on the right to a healthy environment has the potential to unlock novel forms of understanding and using the law to address and redress the grave inequities suffered by individuals and communities exposed to environmental degradation. Climate change is a clear expression of inequity. As the most marginalized and vulnerable people on Earth, the people who contributed the least to the climate problem are those who stand to lose their lives and their hopes for a better future. It thus comes as no surprise that the UN Human Rights Council included climate change in its agenda and warned that climate change poses an existential threat for some countries. One reason for the attention to the relationship between climate change and human rights is the recognition that climate change is having an uneven impact across the world. Climate change is imposing an increasing burden on governments, especially countries with limited resources, in their efforts to protect vulnerable populations and realize human rights. As a shield against inequity, the right to a healthy environment brings to light a sharper sense of human responsibilities toward our shared planet and its people. The right also builds on the synergies between human rights and the environment to establish a stronger framework for accountability for deleterious activities that compromise the planet's vital signs. In the end, the right to a healthy environment is about who we are as humans. The right enhances the appreciation of how humans are not isolated from, but depend on the environment. It also amplifies human awareness on the interrelatedness of the web of life. The right to a healthy environment aids in fostering human consciousness and identity and a culture of respect toward all living beings and nature, which ultimately translates into respect for one another. It is that basic moral truth that we need to respect each other's rights, which lies at the heart of the human rights promise of a world free of want and fear. Thank you for the opportunity to appear today to speak about the corporate responsibility to respect human rights and about interactions in the law on human rights and the environment.
Thank you very much, Dr. Aureliana. Councils, you have questions to our resource person?
A couple of clarificatory questions, Your Honor. Thank you again, Mr. Aureliano. You mentioned something about jurisdiction not identical to territory. Can you expound on that statement?
Certainly. Thank you for your question. The starting point in that analysis is that the Inter-American Convention, like other human rights instruments, establishes that the state has an obligation to respect rights of persons within its jurisdiction. The court considered that the term jurisdiction goes beyond territory. It is not equivalent. Usually, the exercise of jurisdiction will be coterminous with territory because the state may and will exercise jurisdiction over its territory. But there may be instances where a state may exercise jurisdiction outside of its territory in specific situations, and those situations are permissible under certain grounds established in international law. For example, a state may exercise jurisdiction over environmental issues in its exclusive economic zone, which is under the law of the sea defined up to a maximum of 200 nautical miles from the baselines of the coast. That is not the territory of the state. It is a functional zone where the state exercises jurisdiction. Similarly, if a state is occupying another territory, that other territory is not an element of the territory of the state, but the state nevertheless is exercising jurisdiction over that territory. It is controlling it and exercising authority over it. Another example is in respect of persons of the nationality of the state that may find themselves in other countries. The state may validly exercise jurisdiction over those individuals of its nationality in certain respects. What's key in this decision is that the Inter-American Court examines an issue of first impression that had never come before an international tribunal before, which is what happens in a situation where environmental harm originates in one country but affects people in another. Are those people in the other country that are affected by this transboundary environmental harm under the jurisdiction of the country of origin? The answer to that question is quite important, because if they are, then those individuals have a remedy and can hold the country of origin accountable for that harm. But if they're not within the jurisdiction, then the human rights systems do not provide for such a remedy. So therefore, the significance of the question.
Thank you for that. Next question is, can you first define in simple way supply chain that you mentioned earlier as well?
Certainly, and we heard about supply chains also yesterday from expert resource Professor Michael Addo. As I mentioned in my presentation, in a globalized business framework, corporations will integrate their business practices with many other participants in the value chain. They may, through procurement or purchase agreements, buy raw materials from companies located in other countries. They may employ contractors, or they may employ intellectual property that is coming from other places. All of those steps in the value chain and the supply chain are relevant for the corporate responsibility to respect human rights. Because as articulated by the UN Guiding Principles, a corporation, regardless of its size or location, is responsible to ensure that its operations across all its supply chain do not cause or contribute to human rights abuses.
And a follow-up to that, so in the case of the carbon majors, then would you say that it should conduct due diligence and assess whether the operations of the carbon majors and their supply chains have impacts? For example, in the Philippines, would you say that carbon majors have that responsibility?
One can look at the scope of activities and operations of the carbon majors, the impact of the direct activities such as drilling, or the impact of its suppliers, or the impacts of its products. What are the impacts of burning fossil fuels? The application of the UN Guiding Principles, and specifically the issue of due diligence, allows for a focused scrutiny on the steps that carbon majors should have taken and should be taken to fulfill their corporate responsibilities to respect human rights? For example, have they assessed these potential risks associated to their activities, to climate change and to human rights? Have they disclosed those potential risks? Have they disclosed truthful information, or have they otherwise engaged in a campaign of systematic denial or misinformation? Have they adopted plans to prevent those risks or to mitigate them? Do they have policies in place in order to address these risks? More generally, have they applied their resources to the best of their capacity to prevent and address the risks associated to their activities? These are the kinds of questions that, under a due diligence responsibility of the guiding principles, are relevant in a focused scrutiny over the relationship between carbon majors, climate change, and human rights.
That's very enlightening. Thank you very much. May we process a few more questions, but we will ask later, Your Honor. So probably you can come in for questions.
So you would prefer the
We have a few more
panel
questions,
to
but
ask
maybe
questions
later.
first before you proceed?
Yes, we will still
Well,
process
what's the
some
reason behind
questions.
that?
Still processing the questions.
All right, then I think it would be better if we go into a 10-minute break to allow you to process the information and formulate your questions so that the commission can ask uh, our own questions after you're done examining it. So we'll go into a 10-minute break,
Okay.
or would that be sufficient?
Yes, Your Honor.
All right, thank you. So we will now, the session is over.
All rise. The Honorable Inquiry Panel Chairman, Commissioner Roberto Eugenio T. Cadiz, still presiding. Everyone may be seated.
Session is now in order, back in order. Councils, are you ready to continue with your examination of your witness?
Yes, Your Honor.
Okay, please proceed.
Mr. Marcos Aureliana, for continuation, our question is, can you elaborate on the significance of the advisory opinion of the Inter-American Court to this case before the Commission on Human Rights?
In my view, the advisory opinion of the Inter-American Court of Human Rights is highly significant for this instant case for two reasons. One, it demonstrates that human rights instruments in the Human Rights Project is a living project. These are living instruments. They are not fossilized in time at the time they were drafted. They are meant to address the current challenges facing our generation, facing humanity today. The Inter-American Court's decision shows that the American Convention provides protections for people that are experiencing harm as a result of transboundary environmental issues. This is a novel issue. It's an issue of first impression. It opens the door for thinking, for using the law, for understanding the law in novel ways and applying it also to situations of climate change. That's, I think, a first point regarding the significance of the case. And a second point that I think is worth making is that the advisory opinion also shows that human rights mechanisms are well placed to ensure the effectiveness of the instruments that they are mandated to apply. This is important because the Human Rights Project and human rights instruments is meant to provide those who suffer human rights abuses, the victims of human rights violations, with an effective remedy. And so putting the question of effectiveness of those instruments and the mandate of human rights monitoring mechanisms is at the heart of the significance of the advisory opinion of the Inter-American Court.
Thank you. And a follow-up question on that. In that Inter-American case, or you may call it a subject matter, how did that court approach the science side or environmental side, technical side of the issue? Just, for some, maybe for learning purpose also, how it is to be approached in a human rights investigation like this.
Thank you for that question. Given that the proceedings at the Inter-American Court were of an advisory nature in accordance with its advisory competence, there was no file, no contested issue of fact that would call for an application or a scrutiny of the science. The questions posed to the court were legal questions, and they were addressed by legal memoranda and the amicus curiae briefs that were submitted to the court, which helped the court inform its analysis. And so in that specific instance, these issues did not arise. There are other instances where international courts and tribunals have been confronted with issues of science, and there are various ways in which they have sought to learn more about the science. There is the issue of experts, for example, that are providing testimony and helping a court address the scientific basis. There are other figures of so-called masters of the court which help a court address questions of contested science. But in any event, those issues of scientific character, they may be quite relevant in a specific factual setting because they help determine, for example, in this context, the issues of attribution. When is an extreme weather event the direct cause of climate change? Or otherwise, when is a naturally occurring event aggravated, and by how much? What is the differential in magnitude? Those are questions where scientific evidence becomes very important in helping monitoring bodies establish the facts and then apply legal standards to those facts.
That's very helpful. Thank you. In a hypothetical situation, Mr. Aureliano, that a corporation observed due diligence in the first stage, like it conducted, for example, risks assessment, but failed to take action to address those risks. How would you describe due diligence performance of that corporation?
Due diligence is a rather elastic concept, which allows for a scrutiny over the specific factual situation. So the question is very hard to answer in the abstract. General considerations include: what is the size of the company? What is the supply chain look like? What are the impacts and the risks involved? In the scenario that you're putting forward, where there has been a risk assessment, and so risks, specific risks to human rights have been identified, and yet a corporation does nothing, then it is failing to undertake the steps that are required of it under a due diligence approach as established by the UN guiding principles, because the due diligence responsibility requires companies not just to assess risks, not just to know what is going on, but also to act upon those risks in order to prevent or mitigate, as the case may be. It's not enough to know. The guiding principles establish the corporate responsibility to act in order to make sure that a corporation does not cause or contribute to or benefit from human rights abuses.
So as not to be abstract then, if a corporation, for example, has made human rights statements already, has a climate change commitment already, but those statements and commitment were only in writing, and we see, for example, a different thing happening on the ground, or a different action being undertaken. How would you then describe due diligence performance of that corporation in that example?
Yesterday, we heard Professor Michael Addo speak about statements and commitments as a first step in the 5 steps that he identified in order to discharge this responsibility of due diligence. It's a first step, but it's only a first step. It is an important step, a significant step, because it reflects awareness and commitment. But if there's no action following that first step, or if the action directly contradicts the commitment, then we enter not only the subsequent steps of that due diligence responsibility under the guiding principles, but as also Professor Addo mentioned yesterday, under Pillar 2 of the guiding principles, these expectations that are set upon corporations by society may find expression in the domestic laws of countries. And so, for example, if a corporation is putting information out in the public domain regarding its commitment of respect to human rights in the context of climate change, and yet it is acting in a materially different way, that may be compromising or violating the internal laws of that country's on securities, on the market, on providing information to investors or the public, as the case may be. More generally, one of the great advances in the last decade in international human rights law has been the recognition of the right to information. The right to information entitles every person to know what, in the environmental context, what are the risks imposed on that person or that community as may be. And so if a corporation has committed to respecting human rights and has a policy on climate change, and yet in the hypothetical it is acting in a different way, is distributing materially false information that it knows to be false, arguably the content of the right to information is being infringed, and we can draw a link between human rights abuse as a result of that behavior, the conduct of that company that is not in sync with its commitment.
Thank you. Maybe one last question from us, Your Honors. Could you further explain what is the relevance to the national inquiry of the Inter-American Court Advisory? Specifically the finding that there are specific situations in which state can exercise jurisdiction outside of territory. Specifically, the instant proceeding involves, as you know, companies operating and domiciled all over the world and causing and contributing to human rights harms in the context of climate change. So is there a role for the Philippines in ensuring the protection of human rights from activities that may not at all be occurring in our country, in the Philippines?
One way of addressing that question is to again consider that the issue that was decided by the Inter-American Court of Human Rights is an issue of first impression, where there was no precedent. So what does that tell us? What does that tell the Philippines Commission on Human Rights? What does that tell human rights monitoring mechanisms? That there are no obstacles in the discharge of its mandate in the interpretation of the legal instruments and standards that it needs to apply in order to uphold the rights in question. Guided by the principle of effectiveness, the Inter-American Court was able then to propose and establish an interpretation that enhances the protection of people in the juridical space of the Americas in the face of quite new issues such as transboundary environmental pollution, or in this instance, climate change. One can only be heartened by what could be described as a courageous approach, a novel approach by this court in not shying away from understanding that the issues before it, they are novel, but they're also significant and they're relevant to the world we live in. They're highly relevant to millions of people that stand to suffer as a result of climate change. The specifics of the ruling can be relevant for the facts at hand in this proceeding in a number of ways. They relate, for example, to the responsibility of those states where carbon majors are domiciled in respect of harm occurring to people in other states. There may be issues of recommendations to those states in regard to their state responsibilities to control what those corporations are doing when they affect people outside of their boundaries, in this instance, Filipinos affected by superstorms. There may be other instances where activities occurring within the Philippines may have impacts outside of the Philippines. That is not currently the case at hand, but in the future, this decision may be relevant for fact patterns of that character as well. So that is why I was saying that it unlocks ways of thinking and using the law in order for the law to be able to provide an effective remedy to victims of human rights abuse. I think that that is one consideration, and if I may, there's another one which rests on the right to a healthy environment, because the duty for states to protect this right leads to an inquiry about corporate activities, corporate responsibilities, regardless of where those corporations are domiciled, because the duty of the state and the duty of human rights monitoring mechanism to protect the right to a healthy environment of people under its jurisdiction leads to an inquiry over where is that harm coming from, who is responsible, under what standards can that responsibility be established. All of that is relevant in the Inter-American Court's advisory opinion, the guiding principles and extraterritorial obligations as I have presented earlier.
Thank you again, Mr. Arellano. That is all, Your Honors, from the petitioners.
Thank you very much, Dr. Aureliano. Yep. All right, Attorney Armamento will be fielding some questions.
Okay, thank you, Chair Cadiz. Mr. Aureliana, I agree with your opinion that this inquiry is a performance of our mandate, so there is no problem with jurisdiction. I think the only problem on jurisdiction will come only when we have to enforce certain remedies in a specific territory or state. My problem is this petition is a petition against carbon majors. So I want you to teach us, how are we going to connect the use of fossil fuels to a violation of human rights that can be ascribed directly to a specific person, maybe natural or juridical? What are the elements that should be present in the presentation of the petitioners? Thank you.
Thank you very much, Your Honor, for your question. I think there are two elements to it as I heard it, and I would like to address them in turn. First of all, enforcing a decision in another state's territory would arguably be in contravention with the territorial integrity and equality of nations, which are principles established in customary international law and in the United Nations Charter. But my understanding of what this proceeding will result is that there is not necessarily an enforcement of a decision, but instead there are findings and recommendations. And because of that, the issue of enforcement does not necessarily arise. It is an issue of how to craft recommendations that then can be effective. And in so doing, there's no obstacle, there's no jurisdictional obstacle to elaborating recommendations that have extraterritorial dimensions, because there's no enforcement or exercise of state authority that would otherwise be in contravention with United Nations principles. So that is a first reaction to that part of the question. Second part of the question concerned accountability and how to connect the responsibility of individual carbon majors with climate events. In order for that connection to take place, as also we heard yesterday from other expert resource persons, the science will be critical. the science that is able to quantify the contributions that carbon majors have made to the accumulation of greenhouse gases in the atmosphere on the one hand, so that connects carbon majors with the global climate problem on the one hand, and then the science of attribution, how to connect specific climate events with global climate change. And that is where, again, the science becomes key to show whether a specific event would not have occurred but for climate change. That's one possibility. Or whether a given climate event has been made more likely than not as a result of climate change. Now, those are different causation standards, and the science can help measure that, the science of attribution. So in terms of accountability of the individual carbon majors for the specific climate events, those two scientific pieces, they come together and can help inform that exercise in accountability.
Thank you very much, Mr. Witness. Father Walpole?
I wanted to go back, and if you could kindly elaborate. I think you were speaking of the Thai fishing situation that involves slavery and entrapment of migrants, really. And this was tied to a major food chain or series of food chains in Europe. I don't know if that legally proceeded, but I understand the company did change its practice, or companies. I wanted to understand this because I think also with Shell Petroleum in Nigeria, they were clearly linked to destruction of the source. So many of these cases deal with the sourcing of materials, yeah, and how labor is involved, and therefore human rights abuses occur. What we're trying to do is look at the distribution end and how human rights, or what looks like basic health, is impacted. I don't know if there are any cases going in, when we look at this chain of production to consumption, where we have examples in the, shall I say, the distribution. In this case, it's the distribution of waste. Whether there are cases that would help us.
Thank you, Your Honor, for that question. As you rightly point out, the corporate abuse can take place up the chain in the supply side of things. It can take place, for example, on the treatment of workers, also in the supply side, or it can take place down the chain as a result of the impacts of products, or as a result of the impacts of the company's operations on local communities. There have been examples documenting both sides of this equation of the corporate responsibility in respect of human rights as it relates to the environment. The example of the Thai fishing industry is one where we look at the supply side of things and how is a product produced, in this case caught or harvested, as you pointed out, abuse of migrants, forced labor. We have documented other instances where pesticides are affecting the health of workers. We have and this is all up the chain. Down the chain, we have documented how extractive industries have polluted waterways. They have compromised the right to food of communities. They have displaced indigenous peoples from their lands. they have contributed to deforestation and therefore to upsetting carbon sinks that are very important in the fight against climate change. And so whether it's up the chain or down the chain, the corporate responsibility to human rights, to respect human rights, requires corporations to act with due diligence and ensure that they do not cause, contribute to, or benefit from human rights abuses.
Doctor, you're a doctor, right? Doctor of Laws?
Yes.
Okay, Dr. Aureliano. Thank you very much for coming here and sharing your expertise with the panel. I'd like you to elaborate more on the distinction, because the fact that we are now here hearing this petition means that we have decided that there is no issue concerning jurisdiction. We have resolved that, and we have said that the rationale behind the conduct of this inquiry is that we are mandated by our constitution to investigate allegations concerning violations of human rights of the Filipino people. But this is a court of first impression, in a sense, because the cause of violation is being attributed to climate change, which in turn is being attributed to the business operations of carbon majors, who makes it a bit complicated because most of the carbon majors included in this petition do not even have a nexus. I mean, in the traditional sense, in the Philippines, many of them do not even operate here. They do not even have branches here or agents here. Could you? But you said that you cited earlier, which is very interesting to us, is that the Inter-American Court has repeatedly declared, I mean the International Court of Justice, affirmed the duty of states to avoid causing transboundary harm. And did you say that part of that duty is to discipline companies within its territorial jurisdiction in a manner that would prevent them from causing transboundary harm? Part of that duty of the state is to discipline, right? That the companies operating within its jurisdiction. Am I correct in trying to establish that, trying to define part of that obligation, that it is duty bound to prevent companies within its jurisdiction from causing transboundary harm? Mr. Witness, could you?
Certainly. Thank you, Your Honor, for your question. And the reference to the jurisprudence of the International Court of Justice in my presentation was made to illustrate the reasoning that allowed the Inter-American Court to reach its decision on law. And in that reasoning, the Inter-American Court looked at how the ICJ, for the acronym, had approached questions of transboundary environmental harm, and how it had reaffirmed that the duty to avoid transboundary environmental harm has become a norm of customary international law. This is coming from, first, an advisory opinion on the legality of the use of nuclear weapons, and then in a contentious setting in the so-called pulp mills case between Uruguay and Argentina, where the court made this pronouncement in an industrial setting in respect of pollution, which was then expanded to all kinds of environmental damage in a subsequent case between Nicaragua and Costa Rica. And so the jurisprudence of the ICJ on this matter is now clear. The duty established in international environmental law states to avoid causing significant environmental harm is now part of the corpus of international law. So what does that mean then for what states must do in respect of companies within their territory or registered under its jurisdiction or domiciled? Because it is the state that allows, by virtue of its internal legal order, a corporation to exist under that legal order. The corporation would otherwise not exist if not allowed to register and have the nationality of that state. And so the state is required to control its territory in such a way as to ensure that it is not allowing its territory to be used in a way that harms another state, and that way it can abide by its obligation to refrain from causing transboundary environmental harm. That is in the control of territory. What happens physically, materially in its territory? And so in that sense, it is obliged to, as you put it, discipline companies to make sure that their operations do not cause transboundary environmental harm. But I think we could even go beyond that physical dimension, because as the Inter-American Court also elaborated upon, the fact that a state may allow a corporation to exist, be registered and domiciled under its nationality means that it has the duty to control that corporation as well. And this is where the supply chain also comes into effect, because a company's operations may have impacts outside of that state by virtue of its subsidiaries, by virtue of its operations, by virtue of its supply chains, or by virtue of the impacts of its products. In this instance, climate change. In all those instances, as a legal matter, the Inter-American Court of Human Rights is telling us that the home state, in other words, the state of nationality of the corporation, should take measures to prevent the conduct of that corporation to result in human rights abuses. Now, these are important principles that are derived from this advisory opinion and that build on the ICJ's jurisprudence on the duty to avoid causing transboundary environmental harm.
Now, in regard to that duty, which we may consider as falling under the erga omnes doctrine, or the duty or responsibility of states toward other states to uphold international norms of, in this case, human rights, standards. How could you elaborate on how state-based non-judicial mechanisms, such as our Commission on Human Rights, invoke that right to compel or to convince, maybe not compel, to convince or persuade other states to perform such an obligation? For example, in our specific situation, we are conducting an inquiry regarding the alleged responsibility of certain companies for alleged violations of human rights of Filipino people. How can we invoke that to persuade entities within jurisdictions of other states to participate in this process? Would you have any suggestions?
As you mentioned, Your Honor, this inquiry into the facts and alleged responsibilities is a first step in building an evidentiary base that then can be used to reach out and engage the states of origin of these corporations and the corporations themselves in respect of the state responsibilities of the states of origin and the corporate responsibilities of the entities themselves. As you also hinted, there is no possibility for this commission to compel, because it cannot exercise jurisdiction outside of Philippines territory. But that does not mean that it is impeded from crafting recommendations and reaching out in order for these states to observe their established obligations under international law, or for these entities to observe their corporate responsibilities. I think that there is a fundamental distinction there between compelling and recommending, and between exercising jurisdiction as an act of authority and a recommendation that invites corporations or states to uphold their responsibilities or obligations. That is in the character of a non-judicial monitoring mechanism. If we were in the face of an international court, we would be in a different factual legal platform. But that is in the nature of these proceedings, in my opinion.
I was wondering, just thinking along this idea of pushing the access to remedy a step further, can you envision a situation in the near future where invoking this obligation of states toward each other to uphold human rights, where another state can apply to another state to exercise its jurisdiction as a support to that original state's performance of its mandate to conduct an inquiry, to compel that second state's, using perhaps its compulsory processes, subpoena, whatever, to participate in the inquiry. Did I come up?
Yes, I think so. I think there's two angles to what you're asking, and I'll refer to them in turn. The first one is that in a situation of transboundary environmental harm, also in relation to climate change, where the evidence establishes causation, the origin, the impacts, there is this duty established at international law, and so the state that suffers that harm can invoke and present a complaint against the state of origin of that harm. These are general principles of international law. And so this inquiry and the work of the Commission, for example, could help build an evidentiary basis for the Philippines as a state to invoke the responsibility of other states that have caused the climate problem by failing to control the corporations that are domiciled in their jurisdiction. So that's a first angle that is relevant to your question. Now, I must stress that there are evidentiary questions involved in determining causation, the issues of attribution that we were talking about, and then the questions of the duty to avoid causing transboundary environmental harm. So that's one dimension. The other, in respect of how could this commission obtain other states to cooperate with it so that they could either compel or invite those entities within their territories to appear before it. Now that's a matter of international cooperation between states. there may be questions of committee. There may be questions of if this were a court of law. Again, there could be procedures for the taking of testimony of witnesses, but that's not the situation. And so, how can National Human Rights Institute cooperate with one another, or can they get the cooperation of states when they need to conduct an inquiry in respect of nationals of those states? It's a very good question. In principles, there's no obstacle to effecting that cooperation, and so there's no obstacle for this commission to approach either the entities themselves or the state in which they're domiciled, requesting that cooperation.
Would you? I'd like to get also your opinion on because the commission is planning, in fact, to bring this inquiry to other territorial jurisdictions. In fact, we're going to New York and have this set up to encourage respondents who are not inclined to come here to participate in this, what we also call dialogue on climate change. And we're also planning to go to London because many of the respondents are also based in Europe. Do you see any jurisdictional issues or territorial issues for the Commission on Human Rights of the Philippines conducting an inquiry within those jurisdictions?
In principle, acts of authority of organs of a state in another state would be in breach of the territorial integrity of that other state. And so there could be jurisdictional questions there. For example, in United Nations special procedures, special rapporteurs. So these are special procedures that are established by the Human Rights Council to investigate, monitor human rights situations, either in a specific country or in a specific theme. They regularly conduct country visits. Now, before a special rapporteur decides to go to a country and enters that country invites that special procedure. Otherwise, that fact-finding mission could be seen by that country as an intrusion into its sovereignty. And this is, the special procedures are not courts, they're not judicial bodies, and so there's a potential parallel in calling such an activity a hearing as if it were this setting in which it is an act of authority that's mandated by law and takes place fully within the realm of the internal law of the Philippines. But that could not take place, in my opinion, in another state absent that state's consent. And that state consent could be expressed in various ways. It could be by invitation, but there's no obstacle, I think, for the commission or its members to engage in a dialogue and engage in academic discussion and in other countries in respect of the issues that are appearing before, in this case, or before it's in the general pursuit of its mandate. And so in that sense, having a round table of sorts or some other form of conversation or discussion, even with the respondents in this case and with the petitioners, might not constitute a hearing or an exercise of authority. There's a fine line there, but there is a line. And yeah.
No, we've said from the very beginning that we see this inquiry as more of a dialogue on climate change. That's why we have never invoked any kind of compulsory process, because we do know that we do not have compulsory processes over, in this case, the respondents. So we see this more as a dialogue. And this setup is just a formality. This could have been very well be a roundtable discussion. We do not consider we consider you in fact more as resource persons. No? And in fact, we've been considering other processes where witnesses are combined in one session, where there is a discussion among peers, among academics, among stakeholders on climate change. So, because our thinking is if I or 2 or 3 commissioners or even staff members can go request for discussion with anybody in the States concerning this issue, it is actually not we do not see it as an impeachment upon the jurisdiction. It's conducting a dialogue that will aid us in coming up with our recommendations later on. Is there any jurisdictional issue along that line?
The way that you framed it, Your Honor, as a dialogue and as a conversation would not seem to implicate exercise of authority as if it were a fact-finding mission that we're going to inquire on a specific reality and investigate facts. Instead, as framed, it is more of a conversation about perspectives and views. And in that sense, it is a much broader exercise that may not implicate jurisdictional questions. But having said that, at the same time, one could be mindful of how other countries may see it, and that perspective may ultimately be quite relevant because these activities, as anticipated, are taking place in the territories of those other countries, which are sovereign countries. And so the principles of international law are fluid in that respect, in the sense that there is a margin where there can be a discussion, but at the same time there are also basic principles of sovereignty, equality, territorial integrity that underlie the world order as we know it.
All right. Thank you very much, Mr. Aurelia. Yep. Other questions?
No more, Your Honor.
So it's exactly 12 noon.
So may we move for our resource person to be excused, Your Honor?
Yes, Mr. Witness, thank you very much for coming here, Mr. Resource Person. And you are based in
Washington, D.C.
Washington.
And Human Rights Watch has its main office in New York.
And you hold office there, you personally?
Human Rights Watch has offices in Washington, D.C. and in many other countries. Its main office is in New York.
Okay, because since you'll be going there, we might have request for a longer audience with you as a resource person.
We'd be very happy to engage in further dialogue with you, Your Honor, and with your honors.
Okay, thank you very much, sir.
Thank you.
We can now adjourn for lunch. We'll have a longer lunch. Huh?
Sir, we will resume at 1:30 p.m.
1:30. All right, session is adjourned. Thank you very much.